Hello, this is Alexander Cross, criminal defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond with more videos in the future. So, we received an interesting inquiry here on our YouTube channel. This has to do with being accused of kidnapping his own daughter. Criminal attorney, Alameda County. Kidnapping attorney, Alameda County. Kidnapping, Alameda County. Domestic violence, Alameda County. Attorney, Alameda County. Let's see. I'm separated from my wife. She has a new boyfriend. My 12-year-old daughter says he touches her inappropriately. My daughter left the house and is living with me. Now they accuse me of kidnapping her. What can I do? Because I have a restraining order and I'm not supposed to approach any of them. Yeah, well, first of all, let's talk about that restraining order. If there's a restraining order against all of those people, you violating that restraining order would be a violation of Penal Code Section 273.6, which is a misdemeanor that carries up to 1 year in county jail. If there is a restraining order, including against your child, you need to get permission from the court in order to approach her or any of the other parties. Now, if you have an emergency situation, in this regard, it's not like she was in imminent danger or threat, although she claims that she's been touched multiple times, your daughter. You really should have called the police. This should have been reported to the police, and Child Protective Services should have really gotten involved. Obviously, him touching your daughter is a really serious offense, but you don't want to be charged with the 278 of the Penal Code. That would be kidnapping your own child. That carries up to 4 years state prison. Now, if you can show that you obviously did not have the intention to permanently deprive the other party, your ex-wife or ex-girlfriend, that you were not intending to permanently deprive that person of your daughter, well, then that should be enough so that the DA wouldn't actually file this 273, because it's not like you took her and left the country. That's a little bit different. You take your kid, you leave the country, you are not the parent that had, you didn't have custody, well then, okay, that's a fair 278. But in this instance, there's nothing to show here that you had the specific intent to permanently deprive your ex-wife of her. So I don't think the 278 point is going to fly here. However, you could still be charged with violating that protective order, Penal Code Section 273.6. You may have a defense based on necessity. It may be an imperfect defense. Based on the circumstances, you wouldn't actually go to jail. Your attorney could probably resolve this case in a way that you wouldn't go to jail, and maybe something could be worked out with the DA's office to where the case could even get dismissed. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got in trouble for hit and run in the past. Criminal attorney, Alameda County. Kidnapping, Alameda County. Domestic violence, Alameda County. Attorney, Alameda County.